Can you hear me?
Yes.
Well, thank you.
You have an echo.
Yeah, I think you're.
I don't know
if
why
you're-
that's happening.
You might be joined on. There's two.
Say what? I'm sorry.
Sorry, the stream was echoing. There are two Tom Dixons on the call. I don't know if you're joined twice. If so, that could be part of the echo. Um,
I will take care of that. I thought I got kicked off, and that's why I re-entered. So,
then that's probably the reason for the echo. Mr. Dixon, FYI, now it's saying you're in here 3 times. I don't know if it's actually you on 3 different devices or if you forwarded the link you got to register and that's why it's saying so many are you. But if all 3 are you, we're going to continue to have that echoing problem.
I've tried to leave, and I hit leave, and it doesn't take me off. So I have to admit I'm confused as well. I have not had this problem before.
Why don't you turn your camera on so I can see which one of the several is you, and then I'll remove the other and see if that will fix it. Okay. I'm putting. I can't find any more. Okay. Try speaking now. Let's see if that fixed it. You're muted, so you'll have to unmute.
Can you hear me now?
Yes, and there's no echo. So just stay in the Zoom, and if any others with your name pop up, I'll just leave them in the waiting room.
Thank you. Sorry about that.
No problem.
Okay, can everybody see and hear me?
Yes.
Okay, Ms. Federico, are you ready to go?
Yes, I am.
And Ms. Boulay?
I am.
Okay, we are on the record in the Colorado Public Utilities Commission's proceeding number 25R-0468ALL. My name is Connor Farley. I am the administrative law judge assigned to this proceeding. It is now approximately 11:05 a.m. on May 20th, 2026. This continued remote public comment hearing was scheduled at the original remote public comment hearing on February 17th, 2026. That oral decision was then memorialized in decision number R26-0284-I that issued on May 1st, 2026. This continued remote public comment hearing was scheduled to allow members of the public to provide comments regarding the proposed amended rules, and most specifically regarding the further proposed changes in attachment A to decision number R26-0284-I. I want to welcome and thank each of you who are participating in this continued remote public comment hearing and in this proceeding more generally. I know it's a big deal for many of you to be here, and I appreciate it. Let me just state at the outset that if at any time I mispronounce a name or refer to someone by an incorrect gender pronoun, I apologize and mean no disrespect. Please simply correct me, and I will endeavor to get it right from then on out. Before we get into the substance of what we're going to do today, I want to provide a little bit of direction regarding this continued remote public comment hearing and how to provide comments here today, as well as more generally in the proceeding. Now, as a general matter, you can provide written or oral comments. Both will be given the same weight. The commission does not give any weight to oral or written comments. However, the commission prefers written comments because many of us are clearer and more persuasive in our written communications than we are in our oral communications. If you would like to submit written comments, there are 4 ways that you can do so. The first one is you can send written comments by email to the following email address: Dora, D-O-R-A, _PUC, _ comments @state.co.us. The second way that you can provide written comments is through the Commission's website. The website address for the Commission is puc.colorado.gov. Once you hit that landing page, you scroll down until you see a box labeled File a Comment or Complaint. You then fill out the form, and when applicable, you select this proceeding number or input this proceeding number, which is 25R-0468ALL, A-L-L. A third way that you can provide written comments is through the U.S. mail. The address for the commission is 1560 Broadway, Suite 250, Denver, Colorado 80202. And finally, you can also call the following number, which is 303-869-3490. You can then leave an oral comment in English or Spanish. That message will be transcribed and then placed in the file for this proceeding in the e-filings. With regard to all of these ways that I've just highlighted for submitting written comments, it's imperative that you make clear in your written comments that the proceeding number for this proceeding. And again, that is 25R-0468 all. That's important to allow the administrative staff or the commission to be able to place your comments in the correct proceeding. If you would like to provide oral comments here today, of course you're allowed to, and you are welcome to do so. But please follow the following steps. First, change your Zoom name to your first and last name. This is important for a clear record and so that I can call on you to the extent you want to provide oral comments here today. Please also use the raise hand Zoom feature to signal you wish to speak. And that can be found at the bottom of your computer screen in the Zoom application. There's a raise hand icon that you can click on. Once you've completed your oral comment, or if somebody prior to you has said what you wanted to say and you no longer want to provide an oral comment, please just click on that icon again to withdraw the raised hand. Please remain on mute with your camera turned off until your name is called. If you do not know how to use the raise hand feature, you may instead turn on your video to signal you wish to speak. To those, if any, who are participating in this hearing by telephone, you will need to dial *9 to use the raise hand Zoom feature. Please listen very carefully for your area code and the last 3 digits of your phone number. When those numbers are called, you will need to dial *6 to unmute yourself. What I see on my screen, if you're participating by telephone, is your area code and then the last 3 digits, which is the reason why if you want to provide oral comment over the phone, that's what you'll hear. Let me give just a few tips on presenting oral comments here today. When you speak, please remember that a court reporter is here today, and she is making a transcript of everything that is said while we're on the record. As a result, it's important for all of us to speak slowly and clearly so that our court reporter can get an accurate transcript. I may interrupt and ask you to repeat yourself or slow down to the extent you don't follow that direction. All of our comments here today while we're on the record need to be verbal. You cannot answer a question or agree with something with a head nod or a head shake one way or the other. Neither of those show up on a transcript. Please avoid speaking over top of each other. That's imperative again for purposes of getting an accurate transcript. If I ask you a question, you may understand where I'm going with my question. You may be inclined to jump in before I'm done with my question. But please try not to do that, because when we speak over top of each other, it's very difficult for the court reporter to accurately transcribe that. If anybody covers all of the points that you wish to make today, please feel free to just state that you agree with that person. You can repeat the points if you want to, but it's unnecessary for purposes of trying to persuade me. So finally, let me just say that when you're called upon to provide oral comments at the outset, please state your name and who you represent here today, what entity you represent, if any, so that we can follow on the transcript who said what and when. Please speak slowly and enunciate as well as possible. And that's it. So with that, let me just tell you my plan for today, but I'm flexible. So If anybody thinks there's a better way of doing this, I'm of course willing to listen, but much like the last public comment hearing, and this is a continuation thereof, I'm going to take any comments that anybody wants to make at the outset regarding anything of any relevance to this rulemaking. Then I have some questions for the groups generally, but also more specifically for individuals, just based on what I've read in written comments. There'll be clarifying questions so that I understand exactly what was said in writing in the latest round in particular of written comments. I then plan to, again, continue this hearing to a later date. And in the interim, I will plan on issuing another interim decision with another round of changes to the proposed rules, followed by another round of written comments. These rule changes are extensive and relatively novel. For my purposes, I need to have at least one more round of proposed changes by me and reaction from all of you so that we can get to as good a place as possible, hopefully, with these extensive and novel rule changes. So with that, what I'm going to do is open the floor to anybody who would like to make any comments here today regarding anything relevant to this proceeding. And I see that Mr. Dixon has his hand raised. So Mr. Dixon, if you would turn on your video, and then you can go ahead.
Good morning, Judge Farley. My name is Tom Dixon. I am the attorney representing the Utility Consumer Advocate. I just wanted to bring up a preliminary matter in the hearing. As you may recall, the Utility Consumer Advocate filed initial comments recommending that public comments be considered evidence in cases and that the commission would attach whatever weight was appropriate to those comments in terms of using it in the evidentiary proceeding. On May 11th, on third reading of the PUC Sunset Bill, House Bill 26-1326, a section 40-6-106.5 entitled Transparency About Electric and Gas Investor-Owned Utility Regulatory Proceedings, Commission Informational Meetings, Annual Reports, and Summary of Public Comments in Commission Decisions. On May 11th, an amendment was added at the request, according to the bill sponsors, Majority Leader Duran and Representative Wilford, that the following sentence was added to that section. They stated it was at the request of Black Hills, and it reads, "Public comments shall not be considered as part of the evidentiary record." And I bring this up because obviously this takes our comments and simply demonstrates that that can't be done. Although the law itself will not take effect till August, I wanted to advise the commission that obviously we're not going to try and pursue it for the remaining months before August. So I wanted just to alert you to that effect as a preliminary matter.
Okay, I appreciate that, Mr. Dixon. That is helpful. And frankly, I had not caught that amendment late in the legislative process. So
it was done on third reading on the floor, and there was no debate. It was simply introduced and was passed on the floor.
Okay, great. Well, thank you for that. So I saw previously, I thought that somebody else had their hand up. Oh, I see. It's Mr. Cohen. I apologize. Whichever one it is, why don't you go ahead and correct me and let me know which one it is.
It is Cowan, but thank you very much, Your Honor. And I guess you could to introduce myself, my make sure this is done properly. My name is Neil Cowan. I'm a manager of regulatory policy for Public Service Company of Colorado. Thank you for holding this today, and happy to address questions as they come up today. But considering another preliminary matter, perhaps that same piece of legislation that Mr. Dixon has referenced, the PUC Sunset Bill, House Bill 1326. There was a number of equity provisions that were added to that bill. I believe they're in sections 2, 7, and 15. One entails a equity task force. And then there are other requirements in there that appear to be, definitely germane to the work that's being done here. And I suppose this is a question for the commission is, do we, try to incorporate those elements from that new piece of legislation, which I guess anticipated to be signed sometime this summer, maybe by August. I think there's a deadline there, but do we try to incorporate those in as part of this rulemaking? So that's the question I'm posing.
Well, what do you think, Mr. Cowan?
Me personally is we've been at this particular rulemaking in various stages for quite some time. Obviously the origin of this rulemaking goes back to 2021 session, Senate Bill 21272. And I would say we're nearly there. So why not pick up these additional items, see how they fit with, what's been drafted, rather than trying to, stop this proceeding, issue rules, then come back and then trying to reconcile any sort of conflicting rules. But I basically am saying it'd be nice to pick up the lot and move forward.
Is there anything in the new legislation, in your view, that does conflict or address new subject matter that we're not currently addressing? So anything that conflicts with what we're addressing currently in this rulemaking, is there any new subject matter that has not been addressed in this rulemaking?
I believe the equity task force would be new subject matter, and I don't believe we've done a finer analysis of any other conflicts. And perhaps I already see a hand up. As well as other folks have perhaps read it a little closer than I have. But so yeah, that's the question I pose. But
okay. Well, thank you for that. Why don't I turn to Carolyn Elam. Again, I apologize if I'm getting that incorrect. Why don't you go ahead?
Thank you, Judge Farley, and you had it correct the first time. It's Elam. I'm Carolyn Elam. I'm here on behalf of the city of Boulder. I'll comment and follow up on Mr. Cowan's comments. We did do a brief review. I'm not an attorney, just a subject matter expert. And I agree. I think the main thing that the statute would add is the equity task force. However, I think it's unclear that that is something that needs to be contemplated in rule. It's direction to the director of the Public Utilities Commission to engage a task force. And I would really see their role as weighing in on future adjustments to rule, as opposed to something that needs to be memorialized through rule. We did not see any other conflict with the red lines that you provided in your decision. We certainly, again, did a quick screen of that once the legislation passed third reading. So felt pretty good about where we were at. So I'm not sure if, and I see Charlotte's got her hand up, but I'm not sure if it materially impacts it. since I'm speaking now, there were just a couple of minor comments we did want to make about the red lines, but first I wanted to just really appreciate what I thought was a really responsive to the comments that were received. I think what you provided really struck a good balance. So we're very supportive of what you put forward as the amended red lines. The two things we would highlight is just ensuring that the rules have longevity. And so we'd recommend replacing the reference to Justice 40 with the criteria that actually underlie the Justice 40 criteria. And that's a census block group where 65% or more of the population is at or below 200% of the federal poverty limit, federal poverty level. So substituting the criteria in rather than referring to Justice 40 itself, since that was a term of art used by a previous administration and is no longer in use. The second one along those lines as well as we'd recommend not being so specific as to reference the Office of Environmental Justice within CDPHE. Agencies rarely change name or overarching role, but often offices within them can change names, be consolidated, change mission, and so just so that there's clarity, we think that the role appropriately captures the responsibility with CDPHE, and think the reference to the office just could create a need for amendment in the future were they to change name or that office to no longer exist and responsibility be allocated elsewhere. So those were just two recommendations we had.
Okay, so change OEJ to CDPHE.
Yeah, and you already have that reference there, so it's read as Office of Environmental Justice within CDPHE, and so we think you could just strike the reference to the office.
Okay, and then the Justice 40 one, that was within the White House of the Biden administration, is that right?
Correct. Mm-hmm.
So
we think the criteria is sound, which is a large portion of the population at or below 200% of the federal poverty limit. So we just substitute those in as the other criteria. So it references disproportionately impacted communities as defined by the mappings from CDPHE, but then there's also a reference to or a Justice 40 community. And we just wanted to include the definition of the Justice 40 community.
Understood. So if that's the sole criteria, I mean, my understanding is nobody's keeping that information or map, the Justice 40 designations updated. But it seems like pretty simple criteria to apply. Is anybody keeping it updated?
I do not know the answer to that. I see Ms. Guevara from CDPHE is the subject matter expert on that. We think the intent is appropriate though, so it certainly would not have a problem keeping that intent in rule.
Yeah, understood. I just remember, and I don't remember who did this or who said this in written comments, but there was some, I believe, criticism of using the Justice 40 data on an ongoing basis. And the argument essentially was that was a child of the Biden administration. It no longer exists at the federal level and could become outdated. It could become outdated. Who knows over what time period? But it seems like, I don't know, it seems pretty, based on your description, it seems pretty basic. So I'd be surprised if it would be a heavy lift for somebody else, some other entity to keep that that information updated. Anyway, I just state that for the group. Maybe somebody can educate me about that. Anything else, Ms. Elam?
No, that was it. And thank you very much. Appreciate the opportunity.
Thank you. So let me go next to Charlotte. Is it Huff? Huff?
You got it right
Huff.
the first time. Thank you,
Okay.
Connor.
I'm getting it right the first time. I should just stop after my first shot, but Anyway, why don't you go ahead? Welcome, by the way.
Thank you, and thank you for the opportunity. I just wanted to chime in with some additional color for public service regarding potential impacts of the legislation that Neil was discussing. Section 7, from my read, creates new requirements for the commission to identify equity impact proceedings. That's obviously already being contemplated, but I do think it is providing a new lens and more prescriptive requirement for the commission to consider those, and specifically those that have the impact, and I'm quoting, to potential to impact the distribution of benefits and burdens to disproportionately impact to communities, workers, and IQ customers, income qualified customers. I do think the mention of workers might be new, so I just wanted to flag that. And, additionally, Section 15 does discuss intervener compensation, which was another topic of this rulemaking. So in general, yeah, I would echo what Mr. Cowan said earlier, that we're just interested in, making sure these are addressed in an efficient manner, potentially through this rulemaking, but, we're not sure what the appropriate procedural path for that would be.
Okay, I appreciate that, Ms. Huff. And let me just say now, so as I understand it, we're addressing this new legislation that was just passed by the General Assembly, not yet signed by the governor, 26-1326. So I don't think I've
That is
actually,
correct.
I don't think I've actually dealt with this legal issue before, but I would think that whether we can address any changes, any new requirements in that legislation turns at least in part on whether the notice of this rulemaking proceeding was broad enough to cover it. So we need to provide notice to the public of any changes in rules. And I'm just doing this off the top of my head, and it's probably better for me to keep my mouth shut on this. But that's what I'm thinking about right now in public services request to at least think about whether anything contained in that bill can be addressed in the context of this rulemaking. So if anybody wants to provide comment on that, I would welcome it. Thank you, Ms. Huff. Is there anything further that you'd like to say?
Not at this time. Thank you.
Okay, thank you very much. Ms. Guevara has her hand up, so welcome. And why don't you go ahead and let us know who you're providing these comments on behalf of first.
Thank you very much. I'm Megan Guevara, and I'm the Director of the Office of Environmental Justice at the Department of Public Health and Environment. And I wanted to provide some clarification regarding the earlier comments related to Justice 40 criteria and its inclusion in the rule, and how that references back to the definition of disproportionately impacted communities that is in statute. So the current statutory definition does not reference Justice 40 kind of broadly as a policy. It speaks specifically to the climate and economic justice screening tool, which is a federal tool that is not currently being updated, but it is referenced in name in statute. So in the disproportionately impacted communities map that is maintained by the Office of Environmental Justice, that is one of the criteria that we include. It does have 8 categories of data that go into that overall tool related to climate change, energy, health, housing, legacy, pollution, transportation, water and wastewater, and workforce development. So those all fold up into that one particular measure. And if the name was changed in the rulemaking, it would no longer align with the data that is available on the map. So it may potentially create confusion that if folks who are referencing back to the map in order to determine if their community meets that particular criteria saw a different nomenclature on the map compared to what is referenced in the rule. So for that reason, we ask you to consider keeping them consistent for the purposes of moving forward. We are aware of the broader policy question of the updating of that data. And as we move forward with our next version of our maps, we are considering opportunities to be able to keep an eye on what is happening at the federal level and what are other opportunities to be able to maintain that data that's still in the state statute, even if it is no longer being maintained at the federal level.
Okay, just for my own clarity here, I mean, so we're talking about the Justice 40 data basically maintained in the White House by the Biden administration. And what I heard you say is that there are, I can't remember how many you listed a few. Was it 8 criteria?
8 criteria that are within that, what we call CGIST data set, yes.
Okay, so it's not just the one that we heard about before.
Correct.
Okay.
And there is a separate component related to household income that is also included in the disproportionately impacted community definition, but we do capture that separately.
Okay. All right. Okay, so what I hear you saying is you're aware of the issue that I raised earlier. I repeated on behalf of other participants, and there are no promises. You're not making any promises, but you're looking into essentially how to maintain and update that data. Go ahead.
Yeah. And we are currently in a public comment period for proposed updates to the next version of the map. So we will have that data and those decisions available after the public comment period closes. And I think the crux of my comments here are mainly for consistency purposes to make sure that the language that's included in the rulemaking is consistent with the language that is used in the maps so that anyone interpreting how those maps apply to the rules will have clarity.
Okay. And so in the current version of our proposed rules, in other words, the version containing the changes that I'm proposing, they are consistent. The nomenclature is consistent with how you all do it.
Yes.
Okay. All right. Got it. Sorry, I'm a little bit slow. I was taking notes and just want to make sure I have this all right.
And if we can provide anything in writing in follow-up, please just let our office know.
Okay. All right. Anything further at this time?
No, thank you.
Okay. Thank you very much. Okay. I'm not seeing any other hands up. Does anybody want to take a crack at the issue that I raised earlier? The legal issue, which is whether we can consider any of the changes in the most recent legislation, 26-1326, in this rulemaking. Okay, I see Mr. Davidson.
I'll take up your challenge, Your Honor. I think that the first thought I had when Mr. Cowan raised this a little while ago was the notice question that you raised initially in your question. And I haven't reviewed this legislation in any detail, so I can't speak to what may be beyond the notice that started this proceeding, but I think we're somewhat limited in the ability to add more things if we can't somehow fit it within the confines of the notice, which I think was where you were starting with your question. And again, I think we'll have to look at the terminology and the legislation and whether that's a possibility or not. The other question, of course, is that it's not effective yet. And if it were vetoed, then we would have done, if we had added something, it would have been beyond the statutory language that otherwise could have been in place if the governor signs it into law. So I agree with you. It's a very interesting question. I've never addressed it before either, but those are my thoughts in response to your offer of taking some comment. Thank you.
Well, Yeah, thank you, and welcome, by the way, Mr. Davidson. Thank you for those comments. So I saw, Mr. Sopkin, I see that you have your hand up, but I saw Miss Herrera, I thought. Yeah, there you are. Ms. Herrera, I see that you turned on your camera, so if you'd like to make a comment, please unmute yourself, introduce yourself, and let me hear what you'd like me to hear.
Yeah, thank you. Jessica Herrera for the record on behalf of the Environmental Justice Coalition, or the EJC. And I don't have an answer to the notice question, but I just wanted to offer that the EJC actually submitted in its initial comments the first round, something that I think it's completely germane to the question. And for full transparency, I was the drafter of those amendments prior to me joining Green Latinos. I was the drafter for the General Assembly. And so for verbatim, those amendments were drafted at the request of Green Latinos. In our initial comments, we recommended that there would be an advisory board, which translated to this equity task force. And then also we comment on intervener status. So I do think that it's completely relevant to continue those conversations, given that the EJC brought it up in our initial round of comments.
Okay, thank you for that. So Ms. Herrera, let me just ask for clarification. Are you saying that you believe it's relevant and appropriate for us to consider the statutory changes contained in 26-1326 because Green Latinas raised them in their initial comments in this proceeding?
That is correct, yes.
Okay. All right. I think there's at least an argument that, what defines the notice for this proceeding was that contained in the notice of proposed rulemaking. So if there is a notice issue, I think, it's defined by what's contained in the notice of proposed rulemaking, and not necessarily in the comments that followed from all of you. But I'm speaking somewhat in the dark here, but that's what my suspicion is. But I appreciate your letting me know this and for your comments. So thank you. Do you have anything else at this point?
No, that's it. Thank you.
Thank you. Mr. Sopkin, I saw that you had your hand up. So why don't you go ahead? And welcome,
Thank
by
you,
the
Your
way.
Honor. Thank you. Yes, I mean, I agree with Mr. Davidson's comments. I also am unsure whether the initial notice is sufficient to cover any statutory changes that occurred. I just wanted to offer the, I guess, preference from my client, Black Hills, that we would rather do one rulemaking rather than two. And so if new notice is required, I believe Your Honor indicated, we weren't planning on making a decision based on this public hearing, that there would be another public hearing. I know there is some process involved with renoticing a rulemaking, but at the same time, I think it would be possible if there is a notice issue to do that and then just to carry forward with this process, including the changes from the new statute. It is difficult for me to imagine the governor vetoing this legislation because I may be incorrect in my understanding, but that would cease the existence of the Colorado PUC. So that seems unlikely. I'm guessing he will sign it. And I just think through this process we should consider any changes in the new legislation to get this done in one grand rulemaking rather than two. So those are my thoughts.
Thank you, and I appreciate that, Mr. Sopkin. I think we'd all prefer the efficiency of 1 over 2. The only question is whether we can get there. And I appreciate your comment about the possibility of renoticing to the extent there is a notice issue currently. So that's something I'll need to contemplate and look into. Because I don't believe I've ever had to do that before. But thank you.
Thank you.
Mr. Barroso, welcome, and I apologize if I mispronounced your name.
You got it right the first time. Thank you, Judge Farley. Good morning, Parks Barroso. I'm an attorney with Western Resource Advocates, and wanted also to respond to your question about the notice issue. I think that after just brief reflection, I would largely agree with my colleague, Mr. Sopkin. In my experience, the Commission has previously taken steps such as issuing a supplemental notice of proposed rulemaking within the same proceeding or docket number, and could put more thought into it, as I'm sure we'd all like to, but would imagine that that could effectively serve the notice requirement while maintaining the same rulemaking and avoiding some of the procedural and time delays of having to do 2 or multiple rulemakings. And so I've seen that in, I believe it was 25R-0468ALL, the clean heat rulemaking from 2021, as well as several other rulemakings in past years with this commission. And so in the spirit of yourself and all of us not needing to get wrapped around the notice axle, I think that the commission does have tools available to it to solve any problems with that recently passed piece of legislation.
Okay, so let me just make sure that I have this proceeding number correct. 21R-0449D as in Delta, did you say?
G.
G, okay. Okay, and can you just hit again the high points about what your memory is as to what happened there that's relevant to what you just said?
Yes, my recollection from that proceeding is that the commission, and it was quite a lengthy rulemaking, and so over the course of the rulemaking, the commission issued a supplemental NOPR, or supplemental notice of proposed rulemaking, which I believe allowed it to consider or issue notice to consider topics that might not have been previously covered in the original NOPR opening the docket.
Okay. Okay, great. Thank you very much for that. That's very helpful. Okay, does anybody else have anything that they'd like to say on this topic, or anything else relevant to this proceeding and this rulemaking? Okay, I'm not seeing anybody pop up, so I will move on at this point. And I'll move on to questions that I have, and let me start generally, and it has to do with the comments that Black Hills made in their initial comments in the latest round of written comments. That is after I issued the interim decision with my further proposed changes, and I believe Mr. Sopkin signed them. So I'm glad you're here, Mr. Sopkin. I mean, is I understood what you were saying. It was essentially commentary on this whole exercise, and I think what you pointed out more generally is that the new legislation, relatively new legislation at this point, imposed obligations on the commission to engage with disproportionately impacted communities, and take into account the commission the equity considerations contained in 21-272, and that I heard you saying that what the commission was doing was basically passing along the burden and the obligation onto utilities, which would have consequences. I think primarily what you were getting at was cost consequences, and inefficiencies added to, well, I'll say less efficiency added to the list of equity impact proceedings contained in the draft rules. So, I'm generally characterizing here. I want to make sure I have it right. So I'll pause and let you correct me.
I don't think a correction's in order. I think you've aptly characterized what we stated. I would say we're approaching this from the standpoint of a smaller utility in the state of Colorado. We're 1/15 the size of XL, for example, and we do not have nearly the manpower or resources to do what this rulemaking is suggesting we do. When we add up all the requirements, what we see is virtually every one of our advice letter and application type proceedings would fall under the category of equity impact proceeding. And what that means, if you look at the laundry list of obligations in the rules, is we have to do a lot of things that we didn't have to do before associated with our filings. And between our gas utility and electric filing, that could be, upwards of 10 or more proceedings a year. And the way we handle our stakeholder outreach now for efficiency purposes is we try to combine them into 1 or 2 meetings a year in order to comply with the already existing requirement we have across a number of types of proceedings that we file. We still, even with that consolidated approach, a lot of times do not get great participation. And when I look at this set of rules, what I see is a requirement specific to each filing that is going to require advanced outreach, and a whole set of requirements associated with each filing. And I could list them off, but you're aware of them. You're doing the rulemaking. That I don't see how we do without adding to our head count, and/or just outsourcing it. And the commission has been quite clear with us. They would like us to do a hard examination of our expenses. We have a denominator issue where we don't have a lot of customers to spread our costs out. And this is another mandate of the commission that clearly would be recoverable from our customers, that is going to add to the cost of every one of our, almost every one of our proceedings. And we frankly don't see a lot of benefit from it. We think that we would have meeting fatigue if we had to do separate outreach meetings before each proceeding. We think it's going to invite more interveners who will come in to say that we have not satisfied the requirements of the statute. So that could lead to delay, refiling issues with the new compensation rules. We think there are more parties that'll come in to our proceedings requesting compensation. when you add the whole thing up, what we see is a lot of cost without a lot of purpose. And what we would rather do is, which is something that we already do in several of our proceedings, which is allocate benefits, whether it's DSM or TEP or whatever the case is. We have classifications for our direct benefits with our customer-facing programs that will benefit disproportionately impacted communities. Those are substantive benefits. What I see in this proceeding are a lot of procedural mandates that, to me, do not necessarily equate at all to improving equity. It's a lot of busy work. It's a lot of check off the box. Did you do this? Did you do that? Did you do the other thing? And there are so many vague terms that it becomes very difficult for us to determine in advance what we have to do, how we meet the obligations, how we satisfy the new burden of proof, how we satisfy the new settlement requirements associated with this. And frankly, we don't, none of these requirements are spelled out in the statute. It's a very broadly written statute that says equity should be taken into account. Okay, let's take equity into account in the context of each proceeding. If equity issues arise, as the commission has the capability to do, it can consider those at that time. Rather than have to satisfy all these requirements up front with each filing, I would much rather have even a late intervention type possibility than having these prerequisites to our filing that could be used against us in every one of our filings by parties saying you didn't meet those obligations. So long story short, we have a meta narrative in our comments, which is we would just as soon the commission adopt what the statute says, deal with it in a proceeding by proceeding basis rather than having all these very prescriptive procedural rules as a way of avoiding the inevitable costs that we would have to impose on our customers. We also have a micro set of comments in which, okay, if you really feel like you have to do some set of rules, we would like you to hone them, take out the unnecessary stuff, make it as efficient as possible. We even had a suggestion of maybe we could have a once a year meeting with disproportionately impacted communities to set forth our expected filing, something like that, to avoid the burdens that this will impose, not just on the utilities, but ultimately our customers. So that's where we are.
Okay, and I appreciate that. Let me ask you just a few questions. Number one, I'm very concerned by the way of background about the cost of this, as you are. So is there any area of the new proposed requirements that bears a disproportionate share of what you view as the increased costs? I mean, in other words, does the pre-filing outreach, can we assign, a large percentage of the increased costs there or anywhere else within the proposed requirements that you're talking about?
Yeah, I mean, if I had to identify the most burdensome issue to us, it is this, identification in advance, and then having to have meetings before each filing, and as part of those meetings, describe exactly what you're doing in the filing to the disproportionately impacted communities and how that affects them, which is going to be difficult for us to do. And then with the actual filing, having to do a report as to how we did that. And then, just the possibilities within each proceeding that parties can come in and make the argument that we somehow didn't satisfy that process, which leads to delay, uncertainty, and again, more costs in just preparing the filing. I mean, this is the most burdensome aspect to us.
Okay.
And I don't mean to offend the commission by saying the statute points to the commission to do a lot of this. I'm just reading the statute. That's what it says. And I think the commission is capable of doing those things, whatever it can do to help us avoid imposing costs on our customers by, by the commission making that identification. The commission in the rules and the rulemaking indicates that it will provide notice to people who have pre-registered as disproportionately impacted communities. If we could have something like that, that would help us a lot rather than us having to do all that work ourselves.
Understood. And I'm certainly not offended in any way, shape, or form by what you said in your initial comments and in the latest round. And in fact, well, I'll put it this way. I don't think at this point I disagree with your characterization. I mean, the way I look at it is, certainly the equity impact proceedings, those categories, I mean, they're quasi-judicial proceedings. And of course, let me just say two things. Number one, I'm not aware that the commission has the resources itself to be able to do all of this itself. So number two, in my mind, given that these are quasi-judicial proceedings, in which we rely on parties to come in and provide us with the information that we need in order to make the decisions, within the proceedings, it does, unfortunately for you, make sense to pass along the burden of finding and providing that information. So I hear what you're saying and I appreciate it. So let me just ask you this. Well, I've got a couple more for you. So, you talked about both here and then in Black Hills comments that currently Black Hills, in terms of its outreach, is conducting 1 to 2 meetings per year, and somewhere in that neighborhood. And basically they're consolidated meetings addressing more than one proceeding. You're not conducting meetings on a proceeding by proceeding basis.
I think that's generally true. It depends on the year, it depends on the docket, but I know we make our best efforts to consolidate all the various requirements we have across proceedings and do 1 or 2 meetings a year.
Okay. Well, it strikes me that, Rule 1603 lists the equity impact proceedings. They're all pretty big proceedings that I would imagine your team and most, if not all, utilities spend a long time preparing for. But the ultimate question I have is whether you could only hold 1 to 2 hearing or meetings a year in terms of outreach. With respect to, let's just assume that in a given year, Black Hills would file 1 of each of the proposed equity impact proceedings. Could you only hold 1 to 2 meetings a year and have enough information about each of those proceedings to have a truly informative outreach meeting with folks? Do you understand what I'm saying? Or what I'm asking?
I do, and I certainly acknowledge that it's an issue with what we're proposing as to how much information we're going to have about each proceeding in the context of let's hold 1 or 2 of these a year. I do think that issue exists regardless, even under this set of proposed rules. If we are to have meetings in advance of the filing, oftentimes, even then, let's say we hold the meeting a month outside of the filing, or even 2 weeks outside the filing. A lot of times we haven't finalized the information. And so even in that context, where we hold multiple meetings per year that are specific to each filing as proposed in this set of rules, it's going to necessarily be deficient in many cases, because as somebody who's practiced in this field a long time, a lot of times the information is coming together at the last minute before the filing to get things finalized. So that deficiency already exists in the context of the proposed rule. I realize that deficiency may be amplified under our proposal with 1 or 2 meetings a year. We would, of course, do the best we can. But again, we don't see this prescriptive requirement in the statute that we have to have a meeting specific to each equity impact proceeding. I think we do the best we can 1 or 2 times a year. That's what we're proposing. And then after you make the filing, to the extent there are equity issues, I think there's enough organized representation in the state, or maybe there will be after these rules go into effect, that these are sophisticated representatives, a lot of these organizations, and they can determine to come in, intervene, and present equity issues, and then the commission deals with that. If that requires a supplemental filing by the company, I think we'd probably rather have that than what we see in these rules.
Okay. All right. All right. Thank you for that. And Dr. Reynolds, I see your hand up. Thank you for being patient. I'm going to come to you in a moment. I just have one more question for you, Mr. Sopkin, and that is, to the extent the commission tried to, in recognition of the different sizes of public utilities within the state of Colorado, try to create essentially different requirements based on the size of utilities. How would we do that? I think we have some rules that do this. I can't remember what they are or where they are off the top of my head. But in any event, if you can give some guidance on that, I'd appreciate it.
Yeah, I'd say it's certainly an interesting proposal. I don't think I can give you that guidance from the hip today. But if that is being contemplated, I think we can make an effort with our next set of comments to identify maybe some things that would be applicable to the largest utility in the state, that maybe would not be applicable to the Black Hills, Atmos's, CNGs, that have lesser manpower, lesser wherewithal to deal with these procedural burdensome requirements.
Okay. All right. Thank you. I appreciate that. And I appreciate all of your comments. So do you have anything further you'd like to say at this point?
I do not. Thank you.
Okay. Thank you. So Dr. Reynolds, I will turn to you. If you could unmute and turn on your video, that would be great. Welcome. Thank you for being here, and go ahead and tell me what you'd like me to hear.
Sure. I'm a policy advisor for Colorado Communities for Climate Action. We're a coalition of 49 local governments, and we represent about 1/3 of the state's population. And I just wanted to offer an alternative experience of engaging the public to what has been talked about so far. For us local governments, this is our bread and butter. It's what we have to do to serve our residents appropriately. We have to engage them early, often, and we find that it makes our decisions better and helps us avoid unnecessary costs. So I just want to draw your attention to an example from one of our member jurisdictions, Westminster, where there was a need for public transport for hospital workers, and the city initially talked about developing new bus lines, new timing schedules to ensure that those timings and lines matched up with the shift workers at the hospital. But then the city officials talked to the people who needed the transport, and they said buses weren't going to help them, that they needed some transportation to deliver them from their door or as close as possible from their door to the door of the hospital. And so Westminster developed a microtransit project instead, and they reduced vehicle miles traveled, greenhouse gases, got people to work on time, and made their quality of life better. And that's a really good example of how early engagement and equitable engagement actually reduces costs instead of developing a complicated transit plan that wasn't actually going to serve anyone's needs. And so this is something that I think is really important to consider as you're looking at these rules, is that this can actually result in avoided costs. And while the assumption is that these rules and the requirements will increase costs, I actually haven't seen anything in the record that estimates what those costs would be or how significant they would be to the regulated entities. That's something I think we would all really appreciate seeing, to understand better where the burdens are falling and whether those burdens are worth it because they will alleviate other costs, especially to people who are most vulnerable to pollution, to health impacts, environmental impacts, and financial impacts from utility decision making. So I just wanted to offer that additional perspective. Thank you very much.
Thank you. I appreciate that. It sounds like the decision makers in Westminster probably after the fact wish they'd engaged with the hospital workers before they came up with the initial proposal of more buses. So, okay. Thank you. I appreciate that input. Does anybody else have anything they'd like to say on the topic that I addressed with Mr. Sopkin and more generally Black Hill's initial comments in this latest round of written comments? Okay. Oh, I see a hand just popped up. It's Mr. Hefner. Hopefully I pronounced that correctly. Why don't you go ahead?
Yeah, thank you, Judge Farley. And again, you nailed it on the first try. I'm Dietrich Hefner with the law firm Womble Bond Dickinson, representing Tri-State. And I just wanted to add to your suggestion that maybe you would like to have classifications as between different types of utilities in the rule. There were a number of places in Tri-State's comments where we pointed out that Tri-State does not have retail customers and probably needs to be excluded in some form from aspects of the rule that deal with retail-facing programs like customer notices and similar topics. And so just wanted to support the notion that it may make sense to make different parts of the rules applicable to different types of utilities.
Yeah, and I recall that, Mr. Hefner, your client's comments on this. I'm trying to remember, I'm looking at my notes. How did you propose to basically carve out Tri-State and the fact that Tri-State doesn't have retail customers? I remember you had basically a clause that you wanted inserted to basically specify retail rate regulated entities, I think is what you proposed.
Yeah, that's correct. And we're not necessarily married to that particular language. It's more about the concept of just ensure. A good example is in Rule 1604, which requires utilities to identify how the distribution of benefits and burdens compares to customers generally. And Tri-State doesn't have retail customers generally, so there's nothing against which it could compare for purposes of that analysis. And I think we're just looking for some clarity in the rules that we are not being asked to do something that is, not really possible for a wholesale supplier.
Understood. Understood. I'm just trying to think. I mean, for Tri-State, well, I mean, for your customers, does really any of this apply?
For Tri-State's member systems, of course, they've all elected to be exempt from commission regulation, so they wouldn't be subject to this as the entities serving retail load.
Yeah.
I think there are parts of your proposed rules that would apply to Tri-State. For example, some of the requirements around ERPs or CPCNs where you're talking about particular citing decisions. But the parts that wouldn't apply have to do with, getting down to the retail customer level where it's really Tri-State's members that have those retail relationships and not Tri-State itself.
Got it.
And I'm certainly happy to go through those sections, but I think we've spelled them out pretty clearly in the written comments, and I don't want to take up too much time.
And I believe you have as well, so I don't have any further questions for you on that. So unless you have anything else at this point, I will move on. Thank you very much, and welcome, by the way. So anything further on this topic? All right, well, I tell you what, we are at a little after 12:15. Let's take a break until 12:35. So we will be in recess until 12:35. Thank you. All right, Miss Federico, are you ready to go?
Yes, I am.
And Miss Boulay?
Yes, I am.
Okay, we're back on the record in proceeding number 25R-0468 all. Continuing with this continued remote public comment hearing. And I have some more questions that I'd like to pose, at least initially, to particular people / entities who made comments that I have questions about. And then, of course, anybody else can chime in as well. So, let me start with proposed rule 1004J. And that's the definition of community that I added in the most recent version of the proposed rules. And that reads the word community for purposes of Rule 1004Q5 means a group of at least 50 regulated utility customers. So CEO and others have requested to delete that definition, and they argue that there's no numerical limitation on community specified by the General Assembly in 21-272. So the question I have for those who want it deleted is, doesn't the use of the word community presuppose that there's more than one person within the community? So that's my first question. And more, to put a finer point on it, the legislature used the term disproportionately impacted communities. They didn't use disproportionately impacted individuals or anything like that. So, my read on this is that by use of the word community, that presupposes that it needs to be a group of individuals. And then the question is, how many individuals are necessary in order for them to qualify as a community? And I added this in part, I can't remember who, it was one of the utilities that recommended adding this in the initial set of written comments after the NOPR issued. And it was proposed as a means essentially of providing clarity for the utilities, but I think also in terms of managing cost as well, so that frankly, the outreach engagement required by the new statute would not apply. Well, would only apply once you reached a threshold of number of people. So, I'll open it up. Does anybody have a reaction to that? And Gabby Falcon has raised her hand. Why don't you go ahead, Miss Falcon, and welcome, by the way.
Thank you. Good afternoon, Your Honor. So I'm here on behalf of the Colorado Energy Office. So I take your question to mean kind of where do we draw the line as to what constitutes a community? And as you summarize, CEO is against implementing this kind of 5-person minimum limit. I think, first of all, one of our bigger concerns is that there's no real evidence supporting implementing a 50-person limit. Like there's no kind of background for why we would pick that number as opposed to any other number. And then in terms of kind of what would be the minimum number, I think our response is that, especially because this definition was applying to Q4 specifically, where it's a community requesting to be designated as a community in a certain circumstance, I think this would actually just be drawn on a case-by-case basis. So if one person comes forward and wants this designation, I think it would be within the rights of the agency to decide they're not a community for these purposes. But I think drawing these lines beforehand, especially with a lack of kind of evidence justifying number the other, causes concerns.
Okay, I think I understand, and I definitely agree that any number, I think would be arbitrary. So I understand that. Okay, so I appreciate that. Does anybody else want to weigh in on this? Go ahead, Mr. Davidson.
Thank you, Judge Farley. On behalf of Colorado Natural Gas, I think we were the utility you mentioned that may have raised this concern, and it because of the size of the company and its service territories, which are not integrated, they're disparate from each other. There's about 5 of them, and it's to your point about a definition of a community, it needs to be more than a person, I think, as you've identified. And while 50 may be the number that you've selected, I think we proposed 100, but somewhere in there, I think, is the right number. And Ms. Gina Mace, who's the Director of Regulatory for Colorado Natural Gas, is available to address this on behalf of the company. But from a legal sufficiency standpoint, I think you need a number to identify what a community consists of in order to apply this rule effectively. And I'll let Ms. Mace talk further about it from the company's operational perspective. Thank you.
Thank you. And Ms. Mace, welcome. Please go ahead.
Yes, thank you, Your Honor. I'm Gina Mace with Colorado Natural Gas. And to Mark's point, we did respond in comments, and we were the ones that proposed having a limit. And the reason being is that the definition of community identifies characteristics of a DI community in Rule 1004Q, but it doesn't have any additional parameters as to exactly how to define that community. And to Mr. Davidson's point, in densely populated areas, which are unlike the areas we serve, there are tools to help in separating neighborhoods and identifying those communities. But in some of our more dispersed or rural areas where there might be a few homes or customers or, sparse developments, it's harder for us to identify some of these communities. And so further refinement of that rule is very helpful for us and having a number there.
Okay, and I see that in the proposed rule 1004Q5, it starts out with, in response to a request by a community in a census block group. In a census block group provides some clarity, I would think. How I must confess, I guess I don't remember at least. How are census block groups defined? Is there a number of people, a baseline number of people that need to be included for a separate census block group to be recognized?
Your Honor, I think that's a good question and I think that goes to one of the questions, we're thinking about is, from my understanding, EnviroScreen is a tool that we can use to identify some of those census blocks. But even that tool, some of it can be a little unclear as to what encompasses that census block. And so, that again kind of goes to why we're asking for there to be an additional parameter
to make sure we're capturing those communities appropriately.
Understood. And the purpose of my question, I see your hand has been raised on this, maybe we'll get the answer, is maybe by including the requirement that the community making the request has to be in a census block group, maybe that provides sufficient parameters for to address this concern. But I appreciate your comments, Ms. Mace. Let me turn to Ronnie Kumar. I see your hand is up, and welcome. Please go ahead.
Hi, thank you for the chance to respond to your question. My name is Ronnie Kumar. I am with the Office of Environmental Justice with the Colorado Department of Public Health and Environment. I am the geospatial analyst that maintains the disproportionately impacted community map based on the statutory definition as well as Colorado EnviroScreen. So just to answer your question about census block groups, they are a unit of geography created and maintained by the Census Bureau, and they have between 300 and 6,000 people per census block group. So that's the population unit that the Census Bureau uses, and then they have aggregating upwards from there to county levels. So census block groups are contained within a county.
Okay. And so is it a hard floor of 300 people, or is this a general range?
Oh, I'm sorry. I just reversed those numbers. It's 600 or 3,000 people. Apologies. But according to the Census Bureau, it's, that's the floor they're presenting is 600. I do know they, especially in areas where there could be smaller populations, they might, have that floor be a little bit sort of aggregated to try to not have personally identifiable information released. So I guess I don't want to speak to the technicality of the floor, but they say 600 to 3,000 people. And that's also sort of the way they shape them. So if you look at rural Colorado, they will have bigger census block groups because they're less populated areas.
Got it. Okay, well, this is very helpful. So, I mean, basically by including in proposed rule 1004 Q5 that the community has to be in a census block group, we're basically saying that you got to have, well, you're going to have at least 600 people within that census block group. Well, yeah, maybe not. Okay. I need to think about this further, but I appreciate your information. It's definitely helpful. So, let me, do you have anything further?
I'm definitely available if you have other questions, but at this time.
Okay. I appreciate it. Okay. So does anybody else have any thoughts on this? I'm not seeing anybody raise their hand. So let me just state out loud what I'm thinking about this right now, which is, 1004 Q5 as it's currently written, states in response to a request by a community in a census block group to be classified as a disproportionately impacted community. That's the first clause of that proposed rule. And so I had been focused on the census block group, but I'm not sure that's as limiting as I thought it would be, because the request is made by a community in a census block group. So what I'm trying to balance here is, the need for engagement with the concerns cited by CNG and others, but CNG particularly in this context about clarity and the need for cost control. So that perhaps if there's a community defined by one person within a census block group, maybe that's not a community that a utility should be required to engage. Anyway, that's the tension here that I'm trying to deal with. If anybody else has any thoughts on this, I'd be willing to take them. But let me move on to my next question. So the next question has to do with proposed Rule 1004 Q4. And this is the one that states in part that a community is presumed to satisfy the requirement contained therein if it's in a census block group that A, scores above the 80th percentile in Colorado EnviroScreen, or B, as identified on the disproportionately impacted community map, is within a Justice 40 census tract. And Public Service and I believe Tri-State basically argued, I believe, to get rid of the word presumed in there and make a community who that satisfies either of those two criteria, scoring above the 80th percentile in Colorado EnviroScreen or is within a Justice 40 census tract. Those are the two exclusive means of qualifying under this provision of 1004 Q, which is the definition of disproportionately impacted community. So the question I have, I just want to make sure, is that what Public Service and Tri-State and anybody else who made this argument, what you're looking for is to, in order to turn this into satisfaction of one of those two criteria is the only means by which you qualify as a disproportionately impacted community under proposed Rule 1004 Q4, whether it's just basically removing the word presumed. So if anybody has any thoughts on that, I would appreciate it. I see that Mr. Survey has popped up, so why don't you go ahead, and welcome, by the way.
Thank you, Your Honor. So Ryan Survey for Public Service. In Public Service's interest in this definition is to have a clear definition of what constitutes a DI community, because that definition of DI community is kind of the fulcrum on which this whole rulemaking turns, right? Have we satisfied the notice requirements to DI communities, the outreach and engagement requirements for DI communities, and the other requirements under updated proposed Rule 1604B? They all turn on that definition. And so for us, it's really important that we're able to identify a DI community. And if I may, I'll go a little further that, I think from a policy perspective, it's really important for everybody to be working from the same definition of a DI community. And to the extent that it's not totally clear whether a community is or is not a DI community, I think it's going to be a poor public policy outcome for a bunch of private entities, like utilities that maybe aren't specialized in identifying, and it's maybe not our strength to identify DI communities, to have to be making our own determination as to whether something is or is not a DI community. And so for that reason, the removal of vulnerable population, as a term was helpful for us, because I think that was, somewhat challenging to identify what's a vulnerable population. And I want to be really clear that, we don't necessarily think that vulnerable population shouldn't be the recipients of DI community outreach. It's just that it's really challenging for us to identify whether a community is or is not a vulnerable population. And so the rulemaking, we thought, was a step in the right direction here. But I think that right now it says if you hit those two thresholds that you mentioned, it is presumed to be a DI community. But I think that the reverse isn't true, right? That we couldn't say that if you don't hit those, requirements, that you're not a DI that a community is not a DI community under 1004Q Roman 4. And to go a little further there, that definition says that, communities that, have one of multiple factors, including socioeconomic stressors, vulnerable populations, disproportionate environmental burdens, could still be a DI community. And so we think there's lots of ways to tackle this. And, we saw some different approaches in OEJ's comments and in CEO's comments. And ultimately, we don't, for the utility necessarily have a preferred outcome on, how DI communities are identified. For us, the key thing is just being able to look and to know whether a community is or is not a DI community, so we can make sure we're satisfying those notice and engagement outreach requirements. Is that responsive to your question?
It is. I'm looking more particularly for what change you're looking for in this proposed rule 1004Q Roman 4 to satisfy the concerns that you have.
I think that, if we kept this current structure that had that Roman 4, that one way to do it would be, to remove the presumption and say, this is how you meet those factors. It's being one of those two. It's current, Roman 4A or current Roman 4B. Those are the exclusive avenues to satisfying it. We'd be open, but I really want to be clear that, we'd be open to other approaches here too. For us, it's, drawing clear contours and knowing what is and is not a DI community. So I hope that's helpful, if not super specific.
It is helpful. So let me just throw out this. The rule currently says, the sentence right before the two sub requirements A and B, a community is presumed to satisfy this requirement if it is in a census block group that. What if we replace that with a community satisfies this requirement if it is in a census block group that?
I think I'd want to sit with it, but tentatively, I think that would solve the problem.
Okay. And I understand and appreciate what I hear you also saying, which is you're open to other ways of doing this and are not wedded to this particular language. And I'm not either. So if anybody else wants to make any recommendations on this, I'm certainly open to it. So thank you, Mr. Survey. I see two other people have their hands up. So unless you have something else right now, I'll move on.
Thank you.
Thank you. So Mr. Hefner, I think you were first. So why don't you go ahead?
Thank you, Your Honor. Tri-State largely agrees with the comments that Mr. Survey just made. I think our core interest here is just ensuring that there are clear and objective criteria for what a DI community is. And we very much share the concern that utilities are not in a good position to assess whether a particular community is vulnerable or susceptible to environmental problems or the other items on the list there. And so I think our proposal would be to limit it, at least as far as the current draft goes, limit it to the A and B requirements as the exclusive ways that a community would be considered a DI community. I think we would be open to additional objective criteria where, there's no opportunity to sort of apply subjective factors like vulnerability to determine whether or not you've reached the right communities or not. And it's really just an interest in ensuring that we have either a list or a map or some sort of tool that tells us which communities need to be accounted for rather than asking the utility to go and figure that out on their own.
Okay, I think I understand. So thank you, Mr. Hefner. And
thank you.
Let me move on to Mr. Sopkin.
Yeah, I'll just say I appreciate Mr. Hoffner's comments. I agree with them entirely. So I don't need to restate. I would like to let Your Honor know that unfortunately I have other meetings the rest of the day, and so I'm going to hand for Black Hills this off to Emmanuel Kochian. So if you have any further questions of us, he will be handling that.
Okay. Thank you for letting me know, Mr. Sopkin, and it's been good seeing you. And I'll let you
Thank
go.
you. Thank you.
So hold on. Okay, Kathleen Gegner, I see that your hand is up. Why don't you go ahead and welcome.
Thank you, Judge Farley. My name is Kathleen Gegner with the Colorado Energy Office. So I want to start by saying that it's CEO's understanding that rules 1004Q 1 through 4 are all solely identified on the disproportionately impacted community map. So all the criteria therein would be represented on the disproportionately impacted community map. So utilities should not be figuring out what those communities are besides looking them up on that disproportionately impacted community map. That said, it seems that the troublesome language is around the one in which multiple factors, including et cetera, which was language that CEO had originally proposed in its blue lines to be consistent with what was in statute. If that is confusing or problematic, I think we're comfortable taking that language out and just relying on the A and B criteria, as I think Tri-State and Public Service have indicated. And if also helpful, the original notice of proposed rulemaking had essentially points A and B categorized in, sorry, this is confusing, in Roman 3. And so essentially Roman 3 would be saying, as identified on the disproportionately impacted community map, a community meets these, is disproportionately impacted if it meets these criteria, and then A and B would then be added to that list of criteria. That could be a way to potentially address the utilities concern. But again, we had recommended that language so that it better aligned with statute. But if that is not necessary or is causing issues, we would be fine removing that. But again, want to make clear that 1 through 4 are all represented on the disproportionately impacted community map, and it is not, CEO is not proposing that any entity should be looking outside it for those proposed rules.
Okay, I got it. And so I believe this to be the case, but I haven't looked at the map in a few days. So scores above the 80th percentile and in Colorado EnviroScreen are shown on the map, right?
Yes, so those criteria A and B, and I see the Office of Environmental Justice queued up here, but those are selection criteria on the map. So you can go ahead and click on both of those to identify the communities that meet that criteria.
Got it. The reason why I asked is because B, as it's currently written, starts out with as identified on the disproportionately impacted community map, but A does not. I just wanted that clarification. I thought that was the case, but I just wanted to make sure. So
yeah, and we would support including the additional language on the disproportionately impacted community map. And I think the Office of Environmental Justice proposed that in their green lines, and we would support that.
Okay, great. Thank you very much. Let me move on to Riley Slabaugh. Did I get that?
Yeah, yep, that's correct.
Wow. Okay. Well, welcome and go ahead.
Well, thank you so much, Judge Farley. Riley Slabaugh on behalf of the Office of Environmental Justice. Don't want to reiterate the things that were just covered by CEO, but we do agree that the statute is clear with the presumption language. We don't think it creates any unnecessary ambiguity because especially those A and B subfactors and 4 are reflected in the DI map that is available for entities to be able to look at. And that was it.
Okay, thank you very much. And I see that Ms. Herrera has her hand up, so please go ahead.
Thank you, Your Honor. And I just wanted to say that I believe that under Rule 1004Q5 and 6, the burden of identifying a DIC is actually not on the utilities. From my understanding, Number 5 states that the commission is the one that has to make that determination. It says the commission finds that, you know, these in response to a community's request. So that would be the commission's making that determination. And then for number 6, it's based off the determination of another statewide agency.
Understood. And I think what Mr. Survey and others from the utilities, I think, have been saying is they want this to be as objective as possible for purposes of their pre-filing outreach, so that they can identify exactly which communities they need to engage with. I think that's what they were saying, not so much that the burden was on them with respect to 1004Q. But I may have misunderstood. Anyway, I just thought I'd point that out. Does that have any impact on what you'd like to say, Ms. Herrera?
No, that makes sense.
Okay, great. Thank you very much. So does anybody else have any thoughts on this topic? Okay, let me then move on to my next question, which has to do with 1004Q Roman 5, which starts out with, in response to a request by a community in a census block group to be classified as a disproportionately impacted community. We've already hit on this, but I have a few further questions. The Office of Environmental Justice, I believe, in written comments on this, has stated that the disproportionately impacted community map may not reflect the decision by a statewide agency in a timely way, and it will depend on how the community is defined by the statewide agency. And then it also depends on how often the map is updated. So I'd like to know a little bit more about that, in particular, the first part of that, which is whether a determination by a statewide agency that a community is disproportionately impacted, and whether that decision will be reflected on the map turns on how that statewide agency defines the community. I'd like a little bit more specifics on that, and I see that Ms. Guevara has her hand up, so why don't you go ahead?
Yes, thank you. Once again, Megan Guevara, the Director of the Office of Environmental Justice. And the definition of disproportionately impacted community does include the opportunity for a determination to be made that a community is disproportionately impacted because of several potential historical factors. But it is not clear in the statute that a decision by one agency that a community is designated disproportionately impacted would then be binding on other state agencies. So it would not be our policy to update the map to reflect a decision that the Public Utilities Commission made, since that same map is used by other boards and commissions and other state agencies for different types of decision making. We would be happy to work with the commission to find a way to direct entities to that information. For example, a link on our website that says that the commission may have made this determination, and here is a place to find information about census block groups that have been designated as disproportionately impacted under this prong of the definition. But if we were to add that information to the map, it may create confusion for other users who are applying the definition in different ways.
Okay, So, I mean, this strikes me, but maybe I misinterpreted it, as a little bit different answer than what I think I read anyway, in written comments, more recent ones. Uh, so, I mean, in those written comments, I thought what I'd been told was a determination by statewide agency that a community is disproportionately impacted may not be on the map because of the definition of the community and then just timing issues, essentially, that you're planning on updating on, I think you said something like at least a 3-year basis or something like that. You know, well, you get the point. Now what I'm hearing is that maybe you're not planning on including that information on the map because a determination by any statewide agency that a community is disproportionately impacted is not binding on other agencies. Do I understand this correctly?
Thank you for the clarifying question. So it really gets at two different questions. So we do update the maps based on the full statutory definition of a disproportionately impacted community on a regular cadence, with approximately every 3 years, with the next update in 2027. So those updates would reflect any changes to a community's status based on all of the criteria that are included in the statutory definition. If any one agency is applying a different definition or is designating a community based on the more subjective components of the definition, then that is something that we would not generally include in our mapping updates, since it is not binding for all users. So, for example, if there was a determination that per the earlier conversation, that there had to be a certain number of individuals in a community, or any other determinations that are within the PUC regulations that are not reflected in the statute, then that is not something that we would generally update on the map.
Okay. All right. So that, of course, then that community would have to go from agency to agency, and basically, you know, request to be treated as a disproportionately impacted community on an agency by agency basis.
Yes, right now there is not any policy in place that that would determine how a recognition by one agency would affect that determination by other agencies.
Okay. All right.
Thank you.
Yeah, and while you're here, let me ask one more on this. And I appreciate your comments. This is very helpful. So do you have a process by which a community can dispute whether it's a disproportionately impacted community, either on the positive or on the negative side, if that makes sense?
There is one prong in the definition that is intended to allow a community to dispute that they should be considered disproportionately impacted based on historical factors. But as of now, there has not been a circumstance where a community has brought forward that argument and where any state agency has made a determination on it. So there's not any record for us to point to of that happening to date.
Okay. I mean, is there anything within your office that would allow a community to basically say, hey, we're a community, we've been disproportionately impacted, we think anyway, but that's not reflected on the map. And it should be.
Correct. To date, the issue has not come up in practice, so a determination has not been made. There are circumstances where commissions have decided that they are not going to adopt the disproportionately impacted community definition in full, and have chosen to develop separate mapping tools in order to tailor it to their definition. And our participation in this rulemaking thus far has been around how we can provide guidance so that if the commission prefers to use the existing maps that are available rather than having to produce anything new, that they would be able to do so. But we don't have any examples pertaining to those specific kind of individual determinations where our office has needed to make a decision about whether or not to reflect those on the map. thus far. But I believe we would have the same response even within our office, where if a particular CDPHE purpose made a designation for a community, we would document that on our website in some way, but we would not make a change to a map in a way that it would potentially confuse other decision-making bodies. And I see our attorney, Emily, is weighing in as well, so she may have some additional thoughts there.
Okay. Well, I appreciate it very much, Ms. Guevara, and let me move on to Emily Splitek. Is that correct?
Yes, that's it, Your Honor.
Okay.
So I thought I would jump in here to just say that the Office of Environmental Justice maintains the mapping tools as a resource for state agencies to use when identifying disproportionately impacted communities. My my analysis is that if an agency develops a definition or utilizes the definition within the statute using the tools that the Office of Environmental Justice supports and maintains, then, and someone disagrees with how that has been applied in a particular circumstance or agency determination, that then they would go through a process to challenge that agency determination. So it's on a case-by-case basis, I think, depending on what the agency is doing, how it's incorporating the definition of disproportionately impacted community into the decision that's at hand, and the process that it's using there. So I think it could be unique to different agencies depending on how they're applying that definition.
Okay. All right. Thank you for that, Ms. Splitek. Appreciate it. All right. I think that's all I have on this topic for now. Let me just look at my notes. Okay. Yes, thank you for that. And let me move on to another question. Sorry, bear with me. I'm reading my notes and trying to get to where I need to be. So what I'd like to discuss now is proposed rule 1500B. That's the burden of proof rule. And several of you have objected to the addition of 1500B. On several grounds. I think Public Services said that it's at least arguably inconsistent with other statutes in terms of, basically what the standard is for proving what the burden of proof is and what you need to prove within different types of proceedings. And I think, well, obviously the point is to place the burden, be clear about who bears the burden within an equity impact proceeding. Particularly if within that proceeding, any new burdens or continuation of existing burdens are going to happen as a result of the proceeding. So, and I think the argument's been made as well. I know that it's been made that Rule 1604B Roman 4 basically provides the commission with sufficient information regarding that very issue. And the current version of 1604B Roman 4 basically, well, it says, give me just a moment. It requires the applicant or advice letter filer to compare the distribution of benefits and burdens of the filing between disproportionately impacted communities and or subsets thereof versus customers generally, including any measures to mitigate disproportionate burdens on and or prioritize benefits to disproportionately impacted communities. So I think the argument is that, you know, including that language and requiring an applicant or advice letter filer in their initial filing to lay this out, that's sufficient and provides sufficient information to the commission to, you know, basically make its determination on that particular issue. I guess I'm wondering, I know how Tri-State feels about this. I know how Public Service feels about this. I guess I'm wondering how others feel about adding proposed Rule 1500B specifying where the burden of proof lies in one of these equity impact proceedings. And I will add that, you know, what I've read and appreciate and understand, and it makes perfect sense, is that Rule 1500 current, well, it would be 1500A under the proposed rules, is sufficient in terms of allocating the burden of proof in all proceedings, and that adding 1500B is unnecessary in that regard. Does anybody have any thoughts? Does anybody agree or disagree with deleting 1500B as being unnecessary and arguably conflicting with other statutes or confusing? Mr. Stoffel.
Good
why don't you go
afternoon.
ahead? Good to see you. Welcome. Please go ahead.
Thank you. Nick Stoffel for Atmos Energy Corporation. So we filed response comments supporting the comments from Public Service in Black Hills, recommending that 1500B be deleted for the reasons that you just identified. But additionally, you know, I think this goes back to the conversation you had earlier, kind of around the scope of this rulemaking and consistency with the statute. And B, the language in B, includes some of what I think is perceived to be part of passing the buck or shifting the burden from the commission to the utilities, particularly in that it would certainly give parties the basis to argue that a utility not only has the burden of proof, but also has the burden to identify any existing or new burdens and then address whether they're being continued or adopted as part of these equity impact proceedings as part of their overall burden of proof in a case. And so I think that's an area where I was looking at 1500B and saw that not only are you adding this burden of proof, which arguably is duplicative of what's already in the rule, but then expanding it to look at specific issues such as whether there are any existing burdens being continued. And then you not only have that on the front end of a utility potentially having that obligation to identify it, you have embedded within it this tripwire issue that I think Mr. Sopkin identified earlier, that, okay, so one of these parties is initiated, it's moving through the procedural process, someone else identifies what they perceive to be an existing or a new burden that was not identified by the utility at the outset. And so then are we in a, go back to go, do not collect $200 situation, repeat your whole process and refile this case? And so I think that's just an example of where these rules create this potential of, having issues arise in the middle of a proceeding that really suggest the need for objective requirements and the ability for everyone to be on the same page regarding compliance at the outset.
Okay. All right, I think I understand. So thank you for that. Does anybody else have any thoughts on this? Okay. Well, there's Mr. Barroso, so why don't you go ahead?
Thank you, Judge Farley, for the opportunity to respond. Parks Barroso on behalf of Western Resource Advocates. I just wanted to offer maybe a countervailing view on this point, which is kind of starting from what I understand the purpose or one of the purposes of this entire exercise to be, which is creating equity impact proceedings, which is to identify a subset of proceeding types where different substantive and procedural attachments or different substantive and procedural requirements attach. And so within that broader goal, it makes sense logically to me that it would be consistent to have that subset of proceedings likewise be subject to a tailored and specific burden of proof standard. There's been some discussion about statutory inconsistency. I think quite the opposite. The enabling statute here under Senate Bill 21-272, CRS 40-1083B requires the Commission in its determination of all adjudications to consider how to best provide equity, minimize impacts, and prioritize benefits to disproportionately impacted communities, and to address historical inequities. I think key in that, in the Commission's determination of all adjudications necessarily implicates the burden of proof in a party in a particular adjudicated case and what must be brought to bear in order for the Commission to make a sufficient determination as required by statute. And just continuing to point to the enabling legislation here, the statute is unambiguous as to the purpose, which is to have the Commission help to correct historical inequities, which are defined as certain communities being historically forced to bear a disproportionate burden of adverse human health or environmental effects. And so the burden language that's referenced here in 1500B has a clear tie to existing statute. The idea of creating a burden of proof specific to this type of proceeding, an equity impact proceeding, is functions to allow the Commission to fulfill its requirement under statute, which is to make a determination in these types of adjudicated proceedings.
Yeah, thank you for that, Mr. Barroso. I mean, one thing I'm just noting as I'm flipping back and forth between 1604 B Roman 4 and then 1500 B. In the former, it's just really kind of a reporting requirement. It's asking for a comparison of the distribution of benefits and burdens between disproportionately impacted communities and customers more generally. And it requires reporting of any measures to mitigate any disproportionate burdens and to prioritize benefits. So it's kind of a reporting requirement. And 1500B is being very direct and basically saying to an applicant, and I'm paraphrasing here, if what you're asking for in this equity impact proceeding is going to continue or impose new burdens, on disproportionately impacted communities and not mitigate, you need to explain why that's in the public interest. So they really are doing two different things in my mind, sitting here right now. And, you know, what it's 1500B is basically saying to applicants or an advice letter filer as well is, like I just said, if what you're asking for, if the relief you're asking for is either going to impose new burdens on disproportionately impacted communities or not alleviate existing burdens on relevant disproportionately impacted communities, well, then you need to tell us why and that is in the public interest. And what I hear you saying, Mr. Barroso, is that in your view, in any event, that's consistent with the purpose of Senate Bill 21-272.
Yes, Your Honor, that's correct. And I would agree. I share your interpretation that the two rules, Rule 1500B and Rule 1604, are distinct, not duplicative. And I think that a way that I think about the distinction that you're teeing up is that 1604 describes much of the information that must be presented, whereas 1500B operationalizes that information by teeing it up for the decision maker at the commission.
Okay, and so I mean, Senate Bill 21-272, I don't think it includes the words public interest anywhere. You correct me if I'm wrong, or anybody else can correct me if I'm wrong. So in a sense, you know, we're making that up, that being the standard here in this proceeding. Number one, do you agree with me? Number two, if you do, does the commission have the jurisdiction / authority to do that? In other words, say, you need to prove that this is in the public interest.
That's a fair question, Your Honor, and I do not have the statute in front of me and haven't done that word search, but I would accept your representation that public interest may not be in there. I think the argument would be that it is part of the commission's broader constitutional mandate and the generally accepted standard of practice at this commission that it makes decisions in the public interest. And so I think there are numerous examples littered through regulation and through statute where public interest is defined as a criteria for the commission to decide upon without it being specifically defined. And I think that that's actually a feature, not a bug, as it allows the commission to exercise its expert judgment in issuing a determination.
Okay. All right, thank you for that. And just FYI for everybody, I just did a search of Senate Bill 21-272 for public interest. It's not in there. If my searching capability is not deficient. So anyway, thank you, Mr. Barroso. I see that Mr. Stoffel has his hand up. So do you have anything further, Mr. Barroso?
That's all for me. Thank you for the time.
Okay, thank you. Mr. Stoffel, why don't you go ahead?
Yeah, I think just continuing this conversation and looking at the statutory language, I think where 1500B runs afoul of the statute, and in addition to kind of adding this public interest standard that's not in the legislation, it's also essentially adding words to the statute, right? The statute requires the commission to promulgate rules requiring that the commission consider how to best provide equity. And all of a sudden now we've got a burden of proof standard that is essentially shifting that kind of resolution aspect to the utility and making it their burden to address those issues. So I think that it's a fair way to distinguish those. It's one thing to say the utilities need to provide certain information as part of their filings to the extent it's available to them to inform the commission's decision-making and the commission's compliance with this requirement. But it's a different thing to then create a burden of proof for the utilities when the statute does not say the commission shall promulgate rules requiring that utilities do these things. It's really on the commission.
Yeah, understood. And I agree with you about your reading of the statute. I guess, the question in my head is whether the commission can satisfy what it's required to do without effectively kind of shifting the burden. In other words, in quasi-judicial proceedings, the way they work is we rely on the parties to present all of the evidence, all of the information, and make the arguments that we need in order to decide each proceeding. I think there's at least it's at least arguably appropriate for 1500B to be added. Whether it's good and the right thing to do is a separate question. But I mean, I understand and appreciate what you're saying. I guess I'll just have to respectfully disagree about what the commission needs to do in order to be able to comply with its obligations under Senate Bill 21-272. Do you have anything further on this?
Nope, thank you.
Okay, thank you. All right. Well, let me move on. So let me move on to Rule 1602 B4. Maybe I'm not right about that. Hold on one second. Okay, I'm sorry. It's 1604A. And there was a comment so 1604A basically addresses identification and engagement with disproportionately impacted communities in advance of filing an equity impact proceeding. And the last sentence of proposed rule 1604A states, engagement prior to a specific equity impact proceeding does not prohibit a utility from having ongoing engagements with disproportionately impacted communities in its service territory. And I'm hoping somebody from Tri-State is here. Tri-State wants to delete that last sentence that I just read, arguing that it could create confusion or unintended implications. And what I'm looking for is an explanation of the unintended implications. So before I do that, I see that Mr. Survey has his hand up. So why don't you go ahead, Mr. Survey?
Yeah, I had raised it, before we'd concluded that last conversation. So just really quickly before we move on, I just wanted to make the final comment that, that you'd maybe highlighted at the beginning of the conversation, which is that existing Rule 1500A actually has served the commission well in a wide range of proceedings and different standards and a wide range of findings that the commission has to make. In public services initial comments to the interim decision, so our second round initial comments, we tried to bring forth some examples of some statutes that the commission has to make findings under, and so hope that that's useful to you. But just wanted to reiterate that, and I'll keep it short here, and all four going on to 1604A here. Thank you.
Yeah, thank you. And I do remember the statutes that you cited, Mr. Survey, and that they were helpful. I'm just, as I was saying, I don't think there's anything in rules specifying what utilities like public service need to do to the extent what they're asking for in an equity impact proceeding. Either it's going to impose new burdens on disproportionately impacted communities, or just maintain existing ones. So I mean, I think 21-272 at least arguably makes clear, which is kind of a contradiction in terms, but that the commission, if the commission is going to approve something that does either of those things, it better have a darn good reason for doing it. And so I don't think anywhere else in the rules does it specify and state to filers in equity impact proceedings exactly that. We need this information so we can make this determination about whether this is appropriate. And my worry is without 1500B, the commission's not going, in order to get information, you need to place the burden on a party. So that, they have the burden of coming forward with the information and making their argument, and everybody else can attack it if they want to. And without specifying that burden, I worry that the commission will not be in a position at the end of these equity impact proceedings with the evidence and argument they need in order to, make this determination. Does that make sense?
It does. I certainly understand the concern. Maybe there's just some respectful disagreement, that I think 1500A has served us well with this respect, but I absolutely understand what you're saying and understand the concern.
Okay. Thank you. So I'm going to move on. Thank you, Mr. Hefner, for popping up. Do you remember what I was asking previously?
I do. I appreciate Mr. Survey speaking so I could remember. I think that was from a filing we made last year. And the concern with that last sentence isn't that we oppose what it says. Certainly Tri-State does enormous amounts of community outreach outside what's required by the rules. The thing we're concerned about is that for those of us that are students of legislative interpretation, it could be read to create a negative inference that stakeholder engagement is not allowed except for where it's specifically allowed.
Yeah.
Right. There's lots of other places in the rules or lots of other types of proceedings where Tri-State does stakeholder engagement that isn't specifically described anywhere in the rules. And we just want to avoid the implication that some sort of commission permission is necessary to do that engagement in other circumstances.
Yeah, and I think that last sentence is, I think the spirit behind it is to address the very issue you're bringing up, which is, essentially you don't need permission from the commission in order to have ongoing engagement with disproportionately impacted communities. So, I do suspect that the sentence could be written better. So maybe I'll take a shot at that in the next round, and hopefully make it clearer.
Great. We can probably try and think on some language for that too in our whatever the next round of comment filings is. And it's really the goal is just to avoid any suggestion that stakeholder outreach is foreclosed in other circumstances.
Understood. So while you're here, let me ask you one more question, and it has to do with 1604F, and that's the one that addresses settlement agreements. And so I tell you what, why don't I do this? I'll pose the question to you, and then we'll take a break, so you're not completely on the spot. And also, we need a break. So let me just pose it. So 1604F addresses settlement agreements and the requirements. in this context of equity impact proceedings. And I believe that you, on behalf of your client, argued that as written, the proposed rule does not provide sufficient flexibility in settlement negotiations. And so I'd just like to know more about that. So why don't we take a break? We're at 1:45. Let's take a break until 2 o'clock. And so we'll be back on the record at 2 o'clock. Thank you.
Thank you.
Okay, Ms. Federico, are you ready to go?
Yes, I am.
And Ms. Boulay?
I am ready.
Great. We are back on the record in proceeding number 25R-0468ALL. And I posed a question to Mr. Hefner before we took the latest break. And I'll get to you in just a moment, Mr. Hefner, but let me pose one other question. Basically to give the person who I hope can provide me with an answer time to think about it while you're answering my other question. So this is for a question for the Environmental Justice Coalition, presumably Ms. Herrera. And let me just read something that was stated in EJC's initial comments of the second round. It's at page 9. And it was a request for, and I'm quoting now, a mechanism through which parties, interveners, or affected disproportionately impacted communities may raise concerns regarding whether a proceeding should have been designated an equity impact proceeding. So the question I will have for EJC is, what kind of mechanism are you looking for? And perhaps more specifically, wouldn't a motion filed pursuant to 16 proposed rules 1603A8 be sufficient for this purpose? Wouldn't it be the mechanism through which somebody could contest whether a proceeding should be an equity impact proceeding? So that will be my question. I wanted to give you the benefit of some time to think about it as well, whoever's going to answer. But so let me turn back to Mr. Hefner and the question that I had about the provision, I think it's 1604F, regarding settlement agreements. And so go ahead, Mr. Hefner, if you remember my question.
I do. Thank you, Your Honor. So Tri-State had proposed some edits, not deletion, but some edits to 1604F. And I would say the most important of those edits are removing the language that settlements must demonstrate how they advance the equity goals. And there's a few different reasons for that. The first one has to do really with the nature of settlements and how they are created. And as you probably appreciate, settlement negotiations require the parties, including the utility, typically to make concessions and trade-offs, and oftentimes accept what they would each consider less than ideal outcomes on individual issues in exchange for a package that they think overall works. And so you put your thumb on the scale a little bit, and I think probably endanger the chances of reaching settlement in some cases if every settlement must affirmatively demonstrate how it advances the equity goals, when there's no such requirement for other topics that are important to the commission, like environmental goals and public interest goals and so on. And I think it takes away some of the nuanced balancing and negotiation that goes on, especially in proceedings with many parties. The give and take is substantial. The number of meetings is substantial. And we think this would make settlement more difficult, and certainly recognize that in other parts of the commission rules, there's a strong preference for resolving proceedings through settlements. The second thing I would say about the advances language is there may be proceedings that are formally designated as equity impact proceedings, but there's no party that in fact raises equity issues. So I think you can imagine a minor substation CPCN, other types of proceedings where perhaps there really is no particular equity issue, and it would be inappropriate, in my view at least, to require this affirmative showing of how the settlement is advancing the equity goals. So I think one of the things we were getting at with the red line is certainly let's have the settlement address the equity issues that were actually raised either in the application or in testimony or so on. But if there were no issues actually raised, it's maybe a little bit of a false requirement to require the settlement to explain how it advances the equity goals. And then the third sort of outside or marginal case I'll mention is it's not uncommon, as you know, to have settlements that resolve some issues but not all issues. And so you can imagine a settlement in which certain issues are resolved but not the equity issues at issue in the proceeding. And that's another case where having the settlement have to explain why it advances equity, even if those issues have been reserved for an evidentiary hearing, would be a bit clunky.
Okay. That all makes sense. So, I mean, the bottom line, and I frankly, I apologize, I don't remember your latest proposed edits specifically on this. But it sounds like Tri-State is not opposed to having settlement agreements address whether it advances any equity issues that were raised in the proceeding.
I think
to that effect.
I would say it a little differently, that I think we're comfortable having the settlement address the issues that were raised in the proceeding. I mean, I think that's essentially standard practice, right? That either in the settlement agreement or the testimony that goes with it, there is an effort to say, how does this settlement address the various issues that were raised by the parties, including, if applicable, the equity issues. The language that gives us concern is let me just read it, requiring that the settlement address how the settlement advances equity to disproportionately impacted communities, when perhaps in some cases that may not be an issue that was actually raised.
Okay. All right. One thing I'll note is in all or virtually all of the settlement agreements that I've reviewed in proceedings that, I've handled, I think there's always a statement in either the settlement agreement or in testimony supporting the settlement agreement that the settlement agreement is in the public interest, or if it's in a rate case, the settlement agreement yields just and reasonable rates, something along those lines. So what I hear you saying I think, but maybe I'm misinterpreting you, is that in these equity impact proceedings on one very key issue, particularly if we keep 1500B in, this settlement agreement, would not expressly address whether it or how it handles, I guess, any equity issues that have been raised. Does that make sense?
Yeah. So again, I think if you go back, and it was attached to our December 19th comments, we provided a red line on that rule, and our red line would still require that the settlement address the equity issues actually raised. It just removes the language, what I'll call the new affirmative requirement to talk about how the settlement advances equity to DI communities. So it's maybe a slight distinction, but we think an important one.
Okay. I'm catching up with you. Let me get there. Okay, I think I understand. So thank you for that, Mr. Hefner. I appreciate it.
Thank you.
So let me move on to Ms. Herrera, and the question that I had, I think it was regarding 1603A8, and whether a motion pursuant to that rule provision would satisfy the desire for a mechanism basically challenging in a proceeding that has not been designated an equity impact proceeding, whether it should be. So, Ms. Herrera, welcome again. Thank you for being here. And why don't you go ahead?
Thank you, Your Honor, for the question. My understanding is that Rule 1603A8 is a catch-all provision that would allow for the designation of an EIP if it's not one of the enumerated types. But the EJC's recommendation is more so to not just having that catch-all provision, which we do appreciate, by the way, but it's just anticipating a mechanism that would allow for an opportunity to raise concerns regarding EIP designation, and particularly within that category of number 8. I do see a situation where it could be contested whether the health and safety of a DIC, is in question. And so I don't have a particular mechanism in mind today, but I think I would be happy to provide blue lines to address a proposed mechanism.
Okay. Well, I would appreciate that if you could do that. Sorry, I'm taking notes. Yeah, it would be great if you could do that. So thank you for responding. And do you have anything further?
No, thank you, Your Honor.
Okay, thank you. So I'm at the end of the questions that I have. So let me just ask finally, this is your last opportunity today, but I'm willing to listen to whatever anybody has within reason. Does anybody have any additional comments regarding anything relevant to this rulemaking? And I see that Matt Lehrman has raised a hand, so why don't you go ahead, and welcome, and thank you for being here.
Thank you. I'm Matt Lehrman. I'm the Senior Policy Advisor for Energy Utilities for the City of Boulder. And we had raised this topic related to Rule 1603A5 on the definition, on the categories of equity impact proceedings. We briefly discussed this in a response, and I saw some additional responsive comments following the last public comment hearing. But Boulder would like to reiterate that we think it's very important that rate cases or advice letters to modify base rates remain in the category of equity impact proceedings. I think there's been concern raised by some other groups that rate cases are retrospective, and we'd like to just again reiterate that they're not. And to give an example, in the current public service electric rate case and in the gas rate case, there are proposals to modify the affordability programs. There's proposals to increase the authorized return on equity, and these are forward-looking, and these are opportunities in rate cases. This is the only opportunity for a customer or a disproportionately impacted community to address this. So by removing rate cases from these categories, it would seem very much contradictory to the purpose of this entire rulemaking.
Yeah, understood. And I think another point that those who are advocating removing rate cases from equity impact proceedings being designated as equity impact proceedings per se is that the utilities are very limited, if not forbidden from their final action being different for disproportionately impacted communities versus all their other customers. In other words, they're not allowed to discriminate in rates beyond broad categories like commercial, residential, large commercial, small commercial. So I think one point they've made is that you're adding a lot of potential cost if it is an equity impact proceeding, but we're limited. In fact, there's really not anything we can do in terms of the final results in rate cases to we can't do anything different from for a disproportionately impacted community versus the rest of our customers within the same rate class. So I'm just noting that. Do you have any reaction to that?
I do, and I think that's right in terms of setting rates. I think our point is more along the lines of rate cases are not exclusively confined to litigating rates. As I was just pointing out,
Right.
there are proposals in the current rate case to change the affordability programs, to add a performance incentive mechanism for power plant operations, some of which may be in disproportionately impacted communities. So when the cases are expanded beyond simply looking at base rates, which they are currently, I think it makes them very right advice letters and rate cases for inclusion in this category.
Okay, understood. Thank you very much for that. Do you have anything further for me on this or anything else, Mr. Lerman?
No, thank you very much.
Okay, thank you. So I have two hands up, and I'm going to get to them in order. First, Mr. Stoffel, go ahead.
Thank you. I appreciate the issue of base rate cases coming up here. And in addition to what you already noted about the standard already being non-discrimination for base rates that has been in effect for decades, I think the other important consideration here is that the focus of the statute is on the disproportionate burden of adverse human health and environmental effects. And so again, that's an area that is very hard to see how that is germane to base rate cases as compared to something like an affordability program, which is potentially involved in a base rate case, but really has nothing to do with a disproportionate burden of human health or environmental effects. And so I think that's kind of, as you're looking at how to appropriately scope these rules, to me, going back to the statute and looking at the harms that this is intended to address, is a place where you could draw that line to find that base rate cases are not the kind of case that was expected to be included for the commission to be addressing these disproportionately impacted communities from what the legislature identified.
Okay, understood. And what were you just reading from? What part of the statute?
That is 42-1083A(I). Right, and you kind of, it has this flow because it says the General Assembly finds and determines and declares that certain communities, both in Colorado and internationally, have historically been forced to bear a disproportionate burden of adverse human health or environmental effects. And then in the next subsection, the purpose of this subsection 3 is to ensure the commission, in exercising its regulatory authority, will take account of and, where possible, help to correct these historical inequities. And so that's referring back to what it had identified in subpart 1 there.
Got it. Understood. Okay.
Thank you.
Mr. Stoffel, thank you very much. And let me turn next to Claire Valentine. Please welcome and please go ahead.
Your Honor. My name is Claire Valentine. I'm a senior policy advisor with Western Resource Advocates. I wanted to follow up on Matt Lehrman's comments and also show support for including rate cases as equity impact proceedings. To address one of the points that came up about how when a utility sets base rates for customers, as I believe either Matt or Judge Farley, you noted, those base rates are not differentiated and non-discriminated among sub-customers in that class. But I think it's also important to consider that the customers in disproportionately impacted communities, particularly those that experience economic challenges, whether that's being, being qualified as an income qualified customer, experiencing lower income, or just generally experiencing, intersectional impacts of being located in a disproportionately impacted community, they experience rate changes differently. And so a customer that say is on the lower end of an income spectrum might feel a rate increase that comes out of a rate case more with greater difficulty than a higher income customer. And so I think in thinking about even while a rate increase may be applied across all customers the same, the energy burden that an individual customer might experience is not the same. So I think it's kind of this difference of equity versus equality, and we would find it important for there to be consideration of how those rate impacts might affect certain customers differently than others. And I think at issue in this rulemaking are factors like what are the notice requirements for equity impact proceedings, and ensuring that communities have sufficient notice about those types of changes is something that would be really valuable to apply to a rate case where then customers and folks in those types of disproportionately impacted communities then become aware of the proceeding, have the ability to provide public comment, etc. So just wanted to share our support for including rate cases as an equity impact proceeding.
Okay, thank you very much. I appreciate the comment. And I see that Mr. Lehrman's raised his hand again. So Mr. Lehrman, why don't you go ahead?
Yes, and I appreciated the comments from Mr. Stoffel. And just in terms of how the statute is defined when thinking about human health, I would again point to rate cases as being the place where cost recovery for power plants is being discussed, which directly relate to the environmental health. But more broadly, when you think about rate cases and affordability, as Ms. Valentine just spoke to, I would encourage you to look at the public comments filed currently in Xcel's electric and gas rate cases when people are talking about choosing between paying their energy bill and buying food or medication in terms of thinking about human health. And so rate cases are just, if anything, like the most relevant category of VIP rather than not relevant at all.
Okay. All right. I think I understand. So thank you for that. Okay. So is there anything further that anybody would like to say by way of comment regarding this rulemaking and specifically the proposed rules? Okay, Mr. Lehrman, you continue to have your hand up. If you could lower it if you don't have anything else to say, I would thank you very much. So I'm not seeing anybody else with a raised hand. So let me tell you what I'm going to do, which is, as I noted at the outset, I'm going to continue this public comment hearing. And I'm going to continue it until August 4th at 11 a.m. And my plan is the same as the last time, which is to say, I plan to issue another interim decision approximately a month ahead of August 4th, in which I'll take another crack at revising the rules in light of all the comments that the commission has received regarding this rulemaking, issue that, and then set deadlines for further written comments, regarding what I'm proposing in the new interim decision that will be forthcoming. And by the way, I saw that a motion was filed to basically be allowed to file comments late. And that motion is granted. The bottom line is that you're all participants here I set deadlines for written comments for my own benefit, so I have sufficient time in which to consider the written comments in advance of the next continued remote public comment hearing. But, you know, I'm going to listen and read all comments that are provided. So I understood the circumstances that led to the motion that was filed, but you don't need to file such motions. It would be very beneficial to me if you could get the comments in, you know, by the deadlines that I include in my interim decisions, but you don't need to file a motion to the extent you can't get your written comments in by those dates. So with that, let me thank all of you for your participation here today and for your responses to the questions that I posed and for all of your comments. They've all been very helpful. So with that, I'm going to continue this hearing until August 4th, 2027 at 11 a.m. and bid you all well. Thank you.